There are things about that land that I never fully understood. Not until the day a man in a $1,200 suit stood in the middle of 80 acres of cracked red Oklahoma clay and told me it was worthless. And even then, it took me a moment to remember what my grandfather had once whispered to me across a fence line, his worn hand pressed flat against the earth like he was listening for something moving beneath it. He said the land remembers things that people forget. I was 7 years old when I stopped understanding what he meant. That was the year my parents died. A tractor rollover on the south field. Spring mud, a slope that had given way before and would give way again. After that, the land and I were strangers. They put me in the Custer County Children's Home in Clinton, Oklahoma, and the 80 acres my grandfather had farmed his whole life sat there without him, without anyone, slowly baking under the flat western sun. The years pass away orphanage years do, not quickly, not slowly, but quietly. You learn not to attach too much weight to things you don't own. You learn to move carefully through spaces that belong to other people. You fold yourself small. I folded myself small for 11 years inside those cinder block walls, and when I turned 18 and walked out with a garbage bag, holding everything I'd accumulated in a decade of living, the county administrator handed me a sealed envelope and told me it had been filed with my name on it since before I was born. I remember standing on the front steps of that building, the August heat pressing down like a hand on the back of my neck, and opening that envelope. Inside was a single folded document, a property deed. 80 acres in Section 14 of Custer County, Township 12 North, Range 17 West. The name on the deed was Harold Eugene Webb. Beneath it, in language I had to read 3 times to believe, was a handwritten transfer declaration signed by my grandfather just 6 months before he died. To my grandson, Elias James Webb, the only one who ever understood what this land is. I didn't know what that meant. I only knew that I had nowhere else to go. Subscribe and tell us in the comments where you're listening from. I drove out to that land in a truck borrowed from a man at the county agricultural office who had known my grandfather slightly and felt sorry enough for me to loan it for a day. The road to the property was unpaved, rutted from the last rain, and by the time I reached the fence line, I had already decided that the county administrator had been right when she told me, without cruelty, simply as a matter of fact, that the land was assessed at almost nothing. Drought had pressed the life out of it years ago. The grass that had once grown along the creek bed was gone. The soil had cracked into a pattern like old china dropped on a stone floor, 1,000 small pieces, each one holding its own hollow space. 2 fence posts had fallen. The windmill was seized solid, its blades locked in the rusted memory of some long-ago wind. But I had nowhere else to go, so I stayed. I won't tell you those first years were anything but hard, because that would be a lie, and this story doesn't have room for comfortable lies. I slept in the cab of that borrowed truck for 3 weeks before I managed to get the farmhouse on the property into a shape I could live inside without the roof actively threatening me. The farmhouse was small. 2 rooms, a lean-to kitchen, a porch that sagged on the south end. Mice had been through it. A family of raccoons had been through it after the mice. I scrubbed it down with water I hauled in from town, patched the porch board with lumber I found stacked behind the collapsed barn, and slept on a cot I bought secondhand from a man at the flea market in Weatherford for $8. I got work at the Haskell Brothers grain operation 12 miles east of town, hauling, loading, driving, whatever they needed. I worked 6 days a week and spent my Sundays on those 80 acres, walking them the way you walk a thing you're trying to understand. I didn't plant anything those first 2 years. The soil was too far gone, the water table too low, the equipment I could afford too small for the scale of what was wrong. What I did was learn. I read everything I could find about soil remediation, about dryland farming, about cover cropping and subsoil compaction, and the particular cruelties of red clay when it is baked under consecutive droughts. And I found, in the farmhouse, evidence of my grandfather. He had lived in that house until the year I was born, then moved to a smaller place in town when the farm became too much for one aging man to work. But he had never sold the land. Everyone in the county thought he was foolish for holding on to it. Land that wasn't producing wasn't worth the tax bill, and the Webb land in Section 14 had not produced anything meaningful in 15 years by the time I inherited it. People around Clinton shook their heads at Harold Webb's stubbornness the same way they would later shake their heads at mine. In the farmhouse, I found his ledgers. 3 of them, stored in a cedar chest that had swollen shut with the moisture of several wet winters, but which I pried open with a screwdriver one November afternoon, when the light was going gray outside, and I had nothing else to do. The ledgers were written in his hand, careful, deliberate, the handwriting of a man who had gone no further than 8th grade, but who understood precision as a form of respect. They recorded every planting season going back to 1951, every rain measurement, every yield per acre, every input cost, every note on soil condition. The early ledgers were full. The later ones grew sparse. But it was what I found tucked inside the back cover of the last ledger that I want you to understand. Not yet, because the time for that is coming, and the truth, when it arrives, needs to arrive in its own order. What I'll tell you now is only this. There was something there, something my grandfather had pressed between the cardboard cover and the back page, like a man hiding a secret in plain sight, counting on the right person to eventually look. I didn't understand it when I found it. I set it aside. That was my first mistake, though not, as it turned out, a permanent one. The land began to respond in the 3rd year. I had been working the soil with a rendered subsoiler, breaking up the hard pan layer 18 inches down that was preventing water from penetrating. I had seeded cover crops, winter rye, hairy vetch, crimson clover, and turned them under in the spring. The creek bed, which had been dry since before I arrived, showed a thin thread of water in February after moderate winter. It wasn't much, but it was movement. The land was not dead. It was only waiting. By the 5th year, I had 20 acres under productive dryland wheat. It wasn't a fortune. It wasn't even close to a living by itself. But when I walked those 20 acres in the early morning, before the heat came up and the day hardened into its business, I felt something that I recognized from nowhere in my own experience, but that felt inherited nonetheless. The particular satisfaction of a man who has worked the ground and found it working back. I had my grandfather's eyes. People said I had his way of moving across a field, deliberately, with my head slightly down, as if I were reading something in the dirt. Whether that was true, or only what people say when they want a story to be tidy, I cannot say. What I know is that the land began to feel less like a burden and more like a conversation. A conversation I was only beginning to learn the language of. My neighbors, what few there were along that stretch of road, gave me a certain quiet respect that rural communities extend to a young man who stays and works when staying and working is difficult. Old Dale Surratt, who farmed the section south of mine, would stop his truck sometimes at the fence line, and we'd talk for a few minutes about moisture conditions, about wheat prices, about the weather that was always either too much or too little of whatever you needed. He had known my grandfather. He never said much about him directly, but sometimes he'd look out over my land with an expression I couldn't fully read, something between recognition and knowing, and then he'd nod once and drive on. I didn't think much about those looks at the time. I was 31 years old, 7 years into the work of this land, when Raymond Webb came back into my life. I say back into my life, though the truth is that Raymond had never really been in my life at all. He was the son of my grandfather's brother, Fletcher Webb, who had left Oklahoma for Tulsa in the 1960s, and done well enough in commercial real estate to erase most of the red dirt from his memory. Raymond had been raised in Tulsa, educated in Dallas, and had made his own money in land development, the kind that involved turning agricultural property into subdivisions and strip malls, the kind that required him to look at the land not as a thing with its own character, but as a number with a potential multiplier. He arrived on a Tuesday in April, driving a black Escalade that looked aggressively out of place on my rutted dirt road. He was 53, 20 years older than me, with the particular ease of a man who has spent his adult life in rooms where other people are nervous. He wore a jacket that cost more than my truck. He shook my hand on the porch with a warmth that felt practiced and smiled with all his teeth. I offered him coffee. He accepted. We sat at the kitchen table, the same table where I ate every meal, read every soil report, balanced every account, and he talked for 20 minutes about family before he got to what he'd come for. Family history, family connections, the importance of the Webb name in Custer County, the legacy of Harold Webb. He spoke about my grandfather with an affection that I noticed he had no actual memories to back up. He mentioned my parents briefly, carefully, in the way people mention tragic things when they want to demonstrate sensitivity, without spending too much time on it. Then he set a folder on my kitchen table and told me what he wanted. He had been contacted, he said, by a development company, Meridian Land Partners, out of Oklahoma City, that was interested in acquiring agricultural properties in western Custer County for a planned wind energy corridor. The county had been identified as a prime corridor for wind turbine installation. The payout for an 80-acre parcel would be significant. He had done the research himself, as family, because he wanted to make sure I was taken care of. He slid the folder toward me. The offer inside was $320,000 for 80 acres of cracked red clay with 20 acres of wheat on it. That was not nothing. I stared at the number for a moment. Then I looked up at Raymond Webb, and I told him I wasn't interested. His smile didn't break. Not exactly, but something around the edges of it changed. He talked for another 15 minutes. He mentioned the difficulty of farming in Custer County, the drought projections, the aging water table, the economics of smallhold dryland wheat. He mentioned carefully that as the only surviving close relative with a meaningful connection to the Webb family legacy, he had an interest in seeing the land put to its highest use. He mentioned more carefully still that there were questions, legal questions he didn't want to have to raise, about the original deed transfer from Harold Webb to me, given that Harold had been elderly and, some people felt, possibly not in full command of his judgment in those last years. That was the first time I heard the threat beneath the courtesy. I told him again that I wasn't interested. I walked him to his car. He left without the warmth he'd arrived with, but he didn't leave the county. I found that out 3 weeks later when Dale Surratt stopped at my fence line with a different kind of look on his face. Not the quiet recognition I was used to, but something closer to worry. He told me that Raymond Webb had been at the county courthouse, that he'd had meetings with a local attorney named Garrett Poole, who handled estate disputes in the area, that there was talk, Dale couldn't tell me more than talk, about the Webb family land and whether the deed transferred me had been properly executed. I thanked Dale and went back to work. But that night, I lay on my cot in the farmhouse and thought about the cedar chest and the ledgers and what I'd found pressed between the back cover and the last page. And I thought about whether I had been foolish to set aside. If this story is moving you, hit the like button and turn on the bell so you never miss another story like this one. The county courthouse in Clinton was a limestone building with a clock tower that had told the wrong time for as long as anyone could remember. I had been inside it exactly once before, the day I filed my first property tax return, 6 months after inheriting the land, sitting across from a clerk named Mrs. Paulette who had entered my information into a system that clearly didn't know what to make of an 18-year-old with no income and 80 acres of agricultural nothing. I went back in late May, 5 weeks after Raymond Webb's visit, because Dale Surratt's worry had stayed with me. The hearing room on the second floor was smaller than I'd imagined it would be for something that felt so consequential. Brown paneling, drop-tile ceiling, a long table with 8 chairs, a flag that had seen better decades. Present in the room when I arrived, Raymond Webb and his attorney, Garrett Poole, a compact man with quick eyes who wore his confidence like a second suit, a county title examiner named Hollis, the presiding official, a woman named Judge Ardith Crane who handled county property disputes from a desk that was too big for the room, and on my side of the table, me. I had not hired a lawyer. I had looked into it. The attorney I had spoken with in Weatherford, a general practitioner who did wills and traffic cases mostly, had told me that contesting a deed challenge was not simple, that the fees would be substantial, and that he'd need a retainer I didn't have. I told him I'd manage. He looked at me the way people had been looking at me since I was 18. Garrett Poole laid out Raymond's claim in the careful, unhurried language of a man who has been paid to sound reasonable while dismantling something. The core of it was this. Harold Webb, at the time he executed the handwritten deed transferred me, had been 79 years old. He had been treated for a minor stroke the previous year. The deed transfer was handwritten, not the standard executed form, not notarized in the conventional manner, but recorded with the county through a process that Poole characterized as irregular. Raymond Webb, as the closest surviving relative of Harold Webb's brother Fletcher, had a legitimate claim to contest the transfer on grounds of testamentary capacity. He placed 3 documents on the table. medical records from a Weatherford clinic, dated 18 months before my grandfather died, a signed statement from a former neighbor of Harold's in town, a man named Clifton Ames who was 84 and whom I had never met, attesting that Harold in his final years had seemed confused on several occasions, and an affidavit from a Tulsa genealogist mapping the Webb family tree, establishing Raymond's kinship. Then he gestured at me. Raymond had been watching me throughout Poole's presentation with an expression of genuine seeming regret, the look of a man who wished things were different and had been forced by circumstance into a painful corner. When Poole finished, Raymond leaned forward slightly. "Elias," he said, and there was warmth in his voice that turned my stomach. "Nobody wants us to go the wrong way for you. You put real work into that land. I respect that. But the fact is that my family has a legitimate question about whether Harold was thinking clearly when he did what he did, and the law has to answer that question." He sat back. He folded his hands. Judge Crane looked at me. "Mr. Webb," she said, meaning me, not Raymond, "do you have anything you'd like to present?" I had brought the ledgers. I spread them on the table. I showed her 7 years of soil records, planting records, yield records in my own hand, and beneath those, 12 years of Harold's records that I had maintained alongside mine. I showed her the property tax receipts going back to the day I first filed. I showed her the deed itself, the handwriting careful and deliberate, dated and witnessed by 2 people whose names I have been able to verify through town records. Garrett Poole questioned the witness's credibility. He questioned the regularity of the filing process. He suggested, not unkindly, that a 17-year-old boy at the time of transfer was not a legally sophisticated party, and that Harold, in his confusion, may simply have wanted to leave something to his grandson without understanding the complexity of what he was doing. The hearing lasted 2 hours. At the end of it, Judge Crane told us she would take the matter under advisement. She expected to issue a ruling within 30 days. 30 days for me to lose everything I had built in 7 years. As we filed out of the room, Raymond came alongside me in the hallway. His attorney had gone ahead. There was no warmth in his voice now. "I know that land isn't worth much," he said quietly, "but I need clear title to move what's underneath it." And then he walked away, and I stood in the hallway of the Custer County Courthouse with the limestone walls going cold around me, turning over those words. What's underneath it? I drove home. I went to the farmhouse. I went to the cedar chest. I took out the thing I had found pressed between the cardboard cover and the last page of Harold's final ledger. I set it on the kitchen table under the single overhead light, and I looked at it properly, for the first time with the patience it deserved. It was a folded document, yellowed, the paper brittle at the creases, but intact. Folded around it was a handwritten letter, 6 pages long, in my grandfather's hand. And folded around the letter was a second document, a state mineral rights filing form, bearing a date stamp from the Oklahoma Corporation Commission, dated September 14, 1979. I read every word of the letter that night. Then I read it again. Then I sat at that kitchen table until 4 in the morning, staring at the ceiling, thinking about what my grandfather had known about that land for 40 years and had told no one, not his wife, not his neighbors, not the county, no one but the land itself, which kept its silence the way land always does. Patient, indifferent, permanent. The letter began, "Elias, if you are reading this, you are the last Webb left who matters. What I'm going to tell you is something I should have told your father, but I thought there was more time. There is never more time. So I am telling you instead, because you are the one who stayed, and the one who stays always inherits the truth. My grandfather had hired a geologist in 1978, a man named Preston Dahl, who worked for a small Oklahoma City firm called Continental Mineral Survey. Dahl had come to Section 14 at Harold's request. Harold had noticed, over years of farming, that the soil in the northeast corner of the property had particular heaviness to it, a darkness under the clay that was unlike anything in the surrounding fields. He'd noticed that a shallow well he dug in 1962 had produced water that smelled faintly of sulfur before going dry. He'd noticed that after rains, the runoff in one low area had an iridescent sheen. Harold Webb had finished 8th grade and farmed the same 80 acres for 30 years. But he had also read everything he could get his hands on about the geology of western Oklahoma. He knew that the area sat atop a formation called the Anadarko Basin, one of the deepest sedimentary basins in North America, one of the oldest and most productive natural gas deposits in the United States. And he believed, without instruments, without a degree, with nothing but 40 years of knowing his ground, that something was down there. Preston Dahl's survey confirmed it. Beneath Section 14, at a depth of approximately 2,400 feet, the survey identified a natural gas-bearing formation consistent with the Anadarko Basin's Moro sandstone deposits. The preliminary estimate, conservative by Dahl's own characterization, suggested a recoverable reserve sufficient to interest commercial development. The field was not enormous. It would not make international news. But it was real, it was documented, and it was directly beneath my grandfather's 80 acres. Harold had done 3 things with this information. First, he had paid Preston Dahl out of his own savings and asked him to keep the survey confidential. Dahl, who was a straightforward man by all accounts, had agreed. Second, Harold had filed a mineral rights claim with the Oklahoma Corporation Commission, separating the subsurface mineral rights from the surface property rights and recording them explicitly in a document that named the trust, the Webb Family Mineral Trust, as the legal holder of those rights. Third, he had named the sole beneficiary of that trust as Elias James Webb, grandson, or in his absence, any surviving direct Webb heir. I was the only surviving direct Webb heir. Raymond was a collateral relative, the grandson of Harold's brother, 2 branches removed. He was not a direct heir under any definition the trust specified. Harold had done all of this in 1979. He had spent the following 38 years farming that land, watching drought take it, watching the value of the surface acre drop to almost nothing, and keeping his silence, not out of indifference, not out of confusion, but because he had understood something that I was only now beginning to grasp. The surface of the thing and what lies beneath it are not the same truth. The land looked dead. It was not dead. It was rich in a way no one could see until they were willing to go deep enough. He had left me the surface, so I would stay. He had hidden the mineral rights trust, so I would have time to understand what staying meant before someone tried to take it from me. And Raymond Webb, I now understood, had already found out, not from my grandfather's documents. He hadn't seen those, but Meridian Land Partners, the development company Raymond had brought to my door, was not actually in the wind energy business. A single phone call to the Oklahoma Corporation Commission's Public Records Office, which I made the following morning, confirmed what I had already begun to suspect. Meridian Land Partners had applied 18 months earlier for an exploratory drilling license in the area of Custer County Township 12 North, Range 17 West. Their application had stalled because they could not establish clean title to the surface rights over the specific section they needed access to. Section 14. They needed my land, not for a wind corridor, for a drill site. Raymond knew. He had done his own research, or someone had done it for him, and he had found what was publicly available, the exploratory interest from Meridian, the general geology of the area, and he had understood that if he could successfully contest my deed and gain control of Section 14, the Mineral Rights Trust would come into question. He was betting that I didn't know the trust existed. He was betting that a man raised in an orphanage with no legal education and no family to advise him would sign the papers he put in front of me or would lose in court, and that either way the land would end up in his hands. He had been 11 years old when Harold filed that Mineral Rights Trust. He had never seen the document. He didn't know exactly what was underneath the ground. He only knew that something was there, and that whatever it was worth fighting for. What he didn't know, what he could not have known, was that an 80-acre parcel of dead Oklahoma clay had spent 40 years waiting for the right person to come and read it properly. I called the Oklahoma Corporation Commission on a Thursday morning. I spoke with a records clerk named Sylvia who had the efficient calm of someone who has handled panicked landowners before. I told her I was a beneficiary of the Webb Family Mineral Trust, filed in September 1979, and I needed to verify the status of the trust and its associated mineral rights claim. I gave her the filing date and the trust name. She put me on hold for 4 minutes. When she came back, her voice had not changed, but I noticed she was speaking more carefully. She confirmed that the Webb Family Mineral Trust was an active filing in the Commission's records. She confirmed that the mineral rights to subsurface resources beneath Section 14 of Custer County Township 12 North, Range 17 West were recorded in the trust's name. She confirmed that the beneficiary designation had never been contested or amended. Then she told me something I had not expected. Meridian Land Partners had attempted, 6 months earlier, to purchase the mineral rights directly from the Commission, which was not how mineral rights worked and which the Commission had rejected. The rejection was in the public record. Meridian had then filed a quiet title action in district court, attempting to establish that the Webb Family Mineral Trust had lapsed due to the death of its creator. That action was still pending. I asked Sylvia to explain what a quiet title action meant in plain language. She said they were trying to make a court declare that the mineral rights no longer belonged to anyone, so they could then claim them. And Raymond Webb's deed challenge, I now understood, was the other half of that strategy. If he could establish that my surface deed was invalid, that Harold had not been competent to transfer the land to me, then the entire Webb estate would revert to probate, and the Mineral Rights Trust would be pulled into that same proceeding in the confusion of a contested estate, with Raymond controlling the surface rights and Meridian controlling the courtroom narrative. The mineral rights could be quietly absorbed. It was elegant in the way that certain kinds of theft are elegant. It relied on my ignorance. It relied on the orphan not knowing what his grandfather had hidden. I drove to Oklahoma City the following Monday. I found the office of a mineral rights attorney named Carol Hutchins, whose firm specialized in Oklahoma basin law. I showed her the documents, the survey, the trust filing, the letter, the Corporation Commission records, the Meridian quiet title action. I watched her read. I watched her read a second time. Then she looked up at me with an expression I recognized as the particular look of a professional who has just realized they are looking at something more significant than the ordinary. She said, "Mr. Webb, who else knows about these documents?" I said, "No one living." She was quiet for a moment. Then she said, "Good. Let's keep it that way for exactly 30 more days." The reconvened hearing took place on the last Tuesday of June. The same room, the same brown paneling, the same flag, the same limestone choir of the courthouses settling around us. Judge Crane sat at her desk with the composed neutrality of someone who has heard enough competing human certainties to stop being impressed by either side's confidence. Garrett Poole was present. Raymond Webb was present. He was dressed again in his $1,200 jacket, and his expression when he saw me enter the room was one of practical compassion, the look of a man who had already written the ending and was performing the appropriate emotion for it. Carol Hutchins sat beside me. She had a briefcase. She placed it on the table and did not open it. Garrett Poole went first, as he had before, laying out the same arguments with additional documentation, a second medical opinion, a letter from a Tulsa state attorney supporting Raymond's capacity challenge. He was thorough. He was persuasive. He was the kind of attorney who fills a room not with volume, but with the quiet pressure of accumulated credentials. When he finished, Judge Crane looked at Carol Hutchins. Carol stood. She said, "Your Honor, the challenge presented by Mr. Raymond Webb's counsel rests on a single premise, that Harold Webb was not of sound mind when he executed the deed transferred to his grandson Elias. We intend to demonstrate not only that Harold Webb was entirely of sound mind, but that he was a man of extraordinary foresight, and that the deed transfer was a final act of a comprehensive legal estate plan that Mr. Raymond Webb has been attempting to exploit for the past 18 months. Garrett Poole looked up from his notes. The first real look, not the managed look of a prepared attorney, but the involuntary look of someone who has heard a word they didn't expect. Carol opened her briefcase. The first document she placed on the table was a Continental Mineral Survey conducted by Preston Dahl in 1978 and 1979. She walked Judge Crane through it in plain language: the geological formation, the depth estimate, the preliminary reserve assessment. She noted the date. She noted that Harold Webb had commissioned the survey at his own expense from a licensed geological firm, that it had been conducted with professional rigor, and that the results had been documented and retained by Harold for 40 years. A man who commissioned a professional geological survey, Carol said, was not a man experiencing confusion. She placed a second document, the Webb Family Mineral Trust filing with the Oklahoma Corporation Commission, dated September 14, 1979. She read the relevant language aloud. The designation of mineral rights, the trust structure, the beneficiary designation naming Elias James Webb. Garrett Poole had gone very still. Raymond Webb was looking at the table. Carol placed the third document. The Corporation Commission's record of Meridian Land Partners' failed attempt to purchase the mineral rights directly from the Commission and the subsequent quiet title action they had filed. Meridian Land Partners, Carol said, is a company with which Mr. Raymond Webb has a documented financial relationship. He is listed as a referring agent in their commission structure for the Custer County acquisition. She placed a fourth document, a Meridian Partnership disclosure, obtained through the District Court's public record on the quiet title case. Mr. Webb did not come to his cousin Elias out of family concern. He came to him because he needed Elias's surface deed to be invalid in order for Meridian's quiet title action to succeed. Elias would have sold for $320,000 and the mineral rights, which preliminary industry assessments value at somewhere between $8 and $15 million in recoverable royalties over a standard 20-year production lease, would have passed the parties who would not have shared that information with him. The room was completely quiet. I had been watching Raymond during this. I want to describe what I saw, because it matters, not for satisfaction, not because his pain was what I was looking for, but because the truth of a thing lands differently on a person who has been hiding from it for a long time. His face went through several changes that were visible only if you were watching carefully. First, a kind of controlled alertness, the professional stillness of a man deciding how to respond. Then, as Carol continued, something underneath that stillness began to move. His jaw tightened. His eyes dropped to the documents on the table. Not to read them, but because he couldn't hold a composed expression and maintain eye contact at the same time. Garrett Poole leaned toward him and said something very quietly. Raymond shook his head once, sharply. Judge Crane had been reading the mineral trust filing. She looked up. "Counsel," she said to Poole, "does your client have a response to the mineral trust documentation?" Poole stood. He was a professional, and he performed his professionalism faithfully. He said that the mineral rights trust, while apparently valid, was a separate matter from the surface deed challenge. He said that the existence of the trust did not address Harold Webb's capacity at the time of the deed transfer. He said that Raymond Webb's motives were not relevant to the legal question before the court. Judge Crane looked at him for a moment. Then she said, "Counsel, I'm going to ask you a direct question. Did your client know about the Webb family mineral trust before today?" Poole looked at Raymond. Raymond's face had gone to something I can only describe as gray, not the color, but the quality, the particular gray of a room after the light goes out. "That's not something I can speak to without conferring with my client," Poole said. Carol placed a fifth document, a text message chain, obtained to the Meridian Partnership disclosure between Raymond Webb and Meridian's acquisition director, dated 4 months before Raymond's visit to my property. The relevant message read, "Webb Trust mineral claim from 79 is the obstacle. Surface title challenge is the path. Orphan heir likely unaware. Proceed." Judge Crane read the printout. She set it down. She looked at Raymond Webb. Raymond was looking at the table. "Mr. Webb," Judge Crane said. Not Garrett Poole. Raymond himself. He looked up. "I'm going to ask you the same question I asked your attorney. Did you know about the Mineral Rights Trust before you initiated this deed challenge?" The room held its breath the way rooms do when the thing everyone has been thinking is about to be said. Raymond Webb, the man with the $1,200 jacket who had arrived at my kitchen table with warmth and family and a folder full of numbers, opened his mouth, and what came out was not the denial I expected, not the carefully lawyered non-answer that Poole had been coaching him toward. What came out was something much smaller than anything he had said in that room before. "Yes," he said, "I knew." The silence after that word was the deepest thing in the room. Garrett Poole closed his folder with the quiet resignation of a man who understands that a case has just ended. Raymond sat without moving for a long moment. When he finally looked up from the table, he looked, for the first time since I had known him, his actual age, not the man age 53 of an experienced developer, but something older than that, something worn down to its structure by the particular exhaustion of a man whose best calculation has just failed. He had gambled on my ignorance. He had built an elaborate mechanism around it, and the mechanism had come apart in a county courthouse with brown paneling and a clock tower that told the wrong time. He looked at me. I don't know what he expected to see. Triumph, maybe. Contempt. The natural expression of someone who has been wronged and has just watched the wronger exposed. What I gave him instead was something I hadn't planned and couldn't fully explain. Simply a steadiness. Not forgiveness. Not yet, but steadiness. The kind that comes from knowing the land under you is solid. He said, "I'm sorry, Elias." 2 words, flat and insufficient. But I believed him in the way you believe something when the circumstances have removed every incentive for performance. I told myself it was just business, that you would know the difference, that you didn't need it the way. He stopped. He shook his head. I told myself a lot of things. I didn't say anything. Carol Hutchins gathered her documents. Judge Crane announced that the deed challenge was dismissed. She referred the matter of Meridian Land Partners' quiet title action to the district court with recommendation that it be dismissed given the demonstrated fraud of its factual predicate. She noted for the record that the Webb Family Mineral Trust was a valid and active legal instrument whose beneficiary was not in dispute. We walked out of the Custer County Courthouse into a June afternoon that was clean and bright and very hot. The clock tower behind us showed the wrong time, as it always had. I stood on the sidewalk for a moment, looking at the flat line of the western horizon. Carol came up beside me. She said, "You'll need to get ahead of the Meridian situation. They'll come back with a new angle eventually." I said, "I know." She said, "What do you want to do with the mineral rights?" I thought about that for a long moment. I thought about my grandfather pressing that survey report between the pages of a ledger, paying a geologist out of his savings, filing a trust document with the Oklahoma Corporation Commission in 1979, and then going back to farming a parcel of cracked clay without telling anyone what he knew. I thought about the 40 years he had waited. I thought about the 80 acres I had spent 7 years of my life learning. I said, I want to do it right. Doing it right took another 18 months. Carol negotiated directly with 3 competing energy companies, not Meridian, who were quietly informed to the district court process that their quiet title action had no merit and that proceeding further would be inadvisable, but legitimate operators with track record of responsible extraction in the Anadarko Basin. We took our time. We read every proposal. We had the geology independently confirmed by a licensed state geologist, which put the recoverable reserve estimate at the higher end of Dahl's original range. The production lease I ultimately signed was with Clearwater Energy Partners, an Oklahoma City firm whose operations director had been in the basin for 30 years, and who negotiated with me like a man who understood that I was not going anywhere. The lease gave me a production royalty of 19%, above the standard rate, which Carol had negotiated hard for, and included a surface protection covenant that limited drilling infrastructure to a small corner of the northeast quadrant and required restoration of any disturbed soil to agricultural standard within 5 years of cessation production. That covenant mattered to me more than the royalty rate. The first royalty payment arrived 13 months after the lease was signed. It was a number I had not let myself think about concretely until I was holding the check, because numbers at large, approached too early, have a tendency to rearrange how you think about everything, and I needed to keep thinking clearly. I sat at the kitchen table, Harold's kitchen table, which I had repaired twice, and which I intended to repair as many more times as it needed, and I looked at the check for a while. Then I put it in the cedar chest, next to the ledgers and the letter, and I went out to walk the land. It was October. The wheat had been in and out, and the cover crop was coming up green along the north field. The creek had been running since March, a real run, not just a thread, fed by a water table that had been recovering slowly over 7 years of conscientious management. 2 fence posts had been replaced. The windmill was turning. Dale Surratt stopped at the fence line. He looked out over the land with the expression I had been seeing on his face for 7 years, the one I had never quite been able to read. Now, standing there in the October light with the check in the house and the land turning green around us, I finally understood what it was. Relief. Your grandfather always said this was good land. Dale said. He was looking at the north field, not at me. Most people thought he was stubborn. I thought he was stubborn too, for a long time. He was quiet for a moment, but stubborn and right aren't mutually exclusive. I thought about Harold Webb spending 40 years telling nobody. I thought about the particular patience of a man who has put something important in the ground and knows it will be found by the right person in the right time. He wasn't stubborn. I said, he was waiting. Dale nodded once and drove on. Raymond Webb called me in November. I let it go to voicemail the first time, and the third time, I answered. His voice was quieter than it had been in the courthouse. Not the professional quietness of a prepared man, but the actual quietness of someone navigating unfamiliar territory. He said he didn't expect anything from me. He said he knew he had no right to ask for anything. He said that what he had done was wrong in a way that he was still. He chose the word carefully. Reckoning with. He said that he had grown up hearing his father speak about the Webb land the way people speak about things they believe were unjustly taken from them, and that somewhere in that story he had made himself a part of a grievance that was never really his to carry. I listened to all of it. Then I said, Harold Webb knew your grandfather was bitter. He told me in the letter. He said Fletcher left because the farm went to Harold, and he never forgave it. I paused. Harold felt guilty about that his whole life. He never thought the land should be a wound between the family. Raymond was quiet, but he also knew, I said, that guilt doesn't mean someone deserves what they want. Another silence. What are you going to do with it? Raymond asked, the money. I thought about that question. I had been thinking about it since the check arrived. The land and what it produced were mine to steward. That was what Harold's letter had said. Not own in a flat possessive sense, but steward. There's a difference between those two words that only becomes clear when you spend enough time with a piece of ground that has outlasted every person who thought they owned it. I told Raymond what I was going to do. I'll tell you the same. The first thing was the land itself. A portion of the royalty income went into a soil restoration fund, formal, legal, structured, dedicated to continuing improvement of Section 14's agricultural capacity, the cover cropping, the subsoil work, the water management. What Harold's 80 acres could grow, given time and care, was still not fully known. I intended to find out. The second thing was a scholarship fund administered to the Custer County Community Foundation, designated for children in the county foster care and group home system. Children who needed, as I had needed, a concrete tether to a future when everything else fell uncertain. Education assistance, vocational training, agricultural apprenticeships for those who wanted them. The name on the fund was Harold Webb's, because the money was his idea, even if he'd never put it in those terms. The third thing was something that took me longer to name. I called it, eventually, the Section 14 Agricultural Learning Cooperative, a formal arrangement with the county extension office and 2 neighboring farms to use a portion of my acreage as a demonstration and training ground for dryland farming techniques specific to western Oklahoma soil conditions. The county extension agent, a woman named Patricia, who had been trying to start something like this for years without funding, cried when I told her. I didn't expect that. I'm still not entirely sure what to do with it. What I know is that Harold Webb hid something in the earth for 40 years, and the earth kept it faithfully, and when the time came, the truth emerged the way things emerge from soil that has been properly prepared. Not with drama, not with violence, but with the quiet certainty of something that was always going to grow. There is a morning I come back to often in my mind. Not because it was dramatic, but because it wasn't. It was March, 2 years after the courthouse hearing. The kind of early morning when the light is just beginning to separate itself from the dark and the land is still cold enough that your breath shows. I was standing at the northeast corner of the property, at the edge of the drilling infrastructure that Clearwater had installed, modest, as they had promised, a small pad and access road, tucked behind a screen of planted cedars that would fill in within a few years. I was standing there with my hands in my jacket pockets, looking south across the fields. The wheat was coming. The cover crop from last fall had done its work and turned under clean. The creek was running. The windmill was turning against a sky that was going from gray to orange to a kind of clear, wide blue that you only get in that part of Oklahoma in early spring. I thought about my grandfather standing somewhere in the same field, pressing his hand to the earth, listening for something. I thought about what it means to stay, to work a thing without being certain of what the work will produce, to hold on to something that everyone around you has written off, not because you're stubborn or naive, but because you understand, at a level below articulation, at the level where knowledge is physical, that the ground under you remembers things that people forget. I am 33 years old. I am still learning what my grandfather buried in this land. Not just the geology, the other things, the patience, the willingness to let the truth develop on its own time, the understanding that the surface of a thing is not the whole truth of it, that what looks dead can be waiting, that what looks worthless can be holding 40 feet down or 40 years forward, something that will outlast every person who laughed at it. The 80 acres are mine in the legal sense, yes, but they were Harold Webb's in a deeper sense, the sense in which a thing belongs to the person who understood it, and they are, in some way I am still working out, not mine to keep so much as mine to continue, to farm and study, and restore and pass on to someone who will do the same. That's the inheritance, not the mineral rights. Those will run out in 20 years, maybe 30. Not the scholarship money. That will be spent, and properly. The inheritance is the act itself, the staying, the willingness to press your hand to the ground and listen for what it is trying to tell you. My grandfather understood something that Raymond Webb, for all his intelligence and all his research, never did. The most important things about a piece of land are the things you cannot see from outside it. You have to go in. You have to stay. You have earned the right to what it knows. I earned that right. It took me 7 years in a courthouse hearing and a letter from a dead man who believed, against all visible evidence, that I was the right person to find what he'd hidden. I think he was right. I think the land thinks so, too. The windmill turns. The wheat comes. The creek runs. The soil is not what it was when I arrived, and it will not be what it is now when I leave. That is the only thing I know for certain about any of this. The land continues, and what we do, it echoes forward into time in ways we will not live to measure. That is enough. It has always been enough. It just took me a while to understand that what looked like nothing was, all along, everything. Thank you for staying with us all the way to the end. Don't forget to subscribe and check out the other stories on screen right now.